The front door was still open when he came back inside. His shoes were still by the mat, his phone still on the table, and his wife was standing there holding a piece of paper she didn't understand. It wasn't the first letter they had received from immigration, but it was the first one that said he might have to leave sooner than anyone expected. That moment, the confusion, the silence, the feeling that something just changed without warning, is what a lot of families are starting to experience right now. My name is Sarah, and I have spent years helping families understand how immigration really works when things move quickly and quietly behind the scenes. I am here to walk you through what is happening so you are not trying to figure it out alone when it matters most. Because what people are calling faster deportations is not just a headline. It is a change in how quickly cases move once they are already in the system. And here is the part most people miss. Do not skip over this. The law itself has not suddenly changed overnight. What has changed is how fast the system is now allowed to act on cases that were already there. I want to say this clearly so you can take a breath. This is not about panic. This is about awareness. Because when you understand how the system moves, you can move with it instead of being caught by surprise. Now let me explain how this actually works behind the scenes, in plain language. When someone is placed into removal proceedings, that is the legal process where the government tries to remove someone from the United States. Their case is handled by immigration court, officially called the Executive Office for Immigration Review, or EOIR, which is the court system under the Department of Justice. At the same time, Immigration and Customs Enforcement, ICE, the federal agency responsible for locating and removing individuals without legal status, tracks the case and prepares it for enforcement. In the past, many of these cases moved slowly. Court dates were scheduled far apart. Paperwork took time. Delays were common. What is changing now is the speed. Cases are being scheduled faster. Decisions are being issued faster. And once a removal order, meaning a final decision that someone must leave the country, is issued, ICE can act more quickly to carry it out. And here is the part immigration attorneys usually explain after a long consultation. The moment a removal order becomes final, the timeline changes completely. Before that point, you have options. After that point, the system shifts into execution. Stay with me, because this next part applies to people who believe they still have time. The first thing I keep hearing from people is this: they cannot deport me quickly because my case has been pending for years. That used to be more true than it is now. If your case is already in the system, faster scheduling means you may get a hearing sooner than expected. And once a decision is made, delays are less predictable. The next thing I hear, often from social media, is this: if you have no criminal record, you are safe from deportation. That is not how the law works. While criminal history can affect priority, immigration status itself, whether someone has legal permission to stay, is what determines whether removal proceedings can happen. Another rumor that spreads quickly sounds like this: they have to give you months of warning before deportation. In reality, once a final order is issued, timelines can move quickly depending on the case. Notice may come through prior court documents, not always as a new warning. And here is another one that causes confusion. If you miss one court date, nothing really happens. Missing a hearing can result in what is called an in absentia order, meaning the judge makes a decision in your absence. That can lead directly to a removal order without you being there to explain your case. And here's the part many careful people do not see coming. Paperwork that was fine months ago may now move quickly through the system. An address that was never updated means you miss important notices. A document not filed on time means losing an opportunity to present your case. Silence in court, not understanding that you can ask for time or clarification, can close doors you did not know were open. Let me tell you about someone I will call Daniel. Daniel had been living in the United States for years, working, raising his children, and checking in occasionally with his case. His court date was originally far out, and he believed he had time, but his hearing was moved up. The notice was sent to an old address. Daniel missed the hearing. A removal order was issued without him present. By the time he found out, the timeline had already shifted. Now I want to be clear. I share stories like this so you can understand how these situations happen in real life, not to identify any one person. And I want to pause here and say something that many people feel but do not always say. Waiting on immigration decisions is heavy. It affects how you plan your life, your work, your family. When things suddenly move faster, it can feel like the ground shifted under you. That uncertainty, that fear of not knowing what comes next, that concern about separation, those are real experiences. But there is still something you control, and that is preparation. Because understanding where your case stands changes what you can do next. Now, I want to speak directly to different situations because this does not affect everyone in the same way. If you have already filed for asylum, meaning you asked the United States for protection because returning to your home country is not safe, and you are waiting for a court date, you need to be ready for that date to come sooner than expected. If you have received a notice to appear, that is the document that starts your immigration court case, and you have been waiting months or years, you should check your case status regularly and make sure your address is updated with the court. If you have a family member who missed a court date in the past and never followed up, this is the moment to take that seriously, because cases like that can move quickly now. If you are living quietly, working, and hoping your case will stay slow, this is where awareness matters most. And here is what I want you to stay for, because this next part is where you take control of your situation. First, confirm your current address is updated with immigration court, meaning the court must know exactly where to send your notices. Second, check your case status regularly through official immigration court systems, so you are not relying on old information. Third, keep copies of every document you have filed or received organized in one place you can access quickly. Fourth, if you receive a notice, read it carefully and respond on time. Even if you are unsure, do not ignore it. Fifth, if you feel uncertain about your case, speak with a qualified immigration attorney, someone trained in immigration law, before making decisions. Now, I need to say something very directly. There are people right now taking advantage of this situation. They are promising to stop deportation immediately or guarantee case approval for large fees. No one can guarantee that outcome. If someone tells you they can fix everything quickly without reviewing your case in detail, that is a warning sign. Let me share one more situation. A woman I will call Rosa paid someone who claimed they could freeze her deportation case. They took her money, filed nothing meaningful, and stopped answering calls. By the time she sought real legal help, deadlines had already passed. And again, I share this so you can recognize the pattern, not to identify any specific person. There is another step many families do not realize they can take. If you are a U.S. citizen or a green card holder, meaning you have the permanent right to live in the United States, and your family member's case feels stuck or unclear, you can contact your congressional representative's constituent services office. That simply means the staff in your local elected official's office who help residents communicate with federal agencies. They cannot change the law, but they can request updates and sometimes help bring attention to delayed cases. And I want to remind you of something important. You are not without rights. You have the right to ask for an attorney. You have the right to understand documents before you sign them. You have the right to ask for clarification in court. You have the right to not sign something immediately if you do not understand it. These are not small things. They are protections. And I want to leave you with this perspective. Immigration has always moved in waves. Sometimes it slows down, sometimes it speeds up. What we are seeing now is a shift in speed, not a complete rewrite of the law. People who stay informed, who keep their documents in order, and who act early when something changes, find a way through situations that once felt overwhelming. So take a breath, pay attention to your case, and move forward with clarity instead of fear. I read the comments carefully, and if you want to share your situation or ask a question, you can write it below. I will do my best to help you understand what is happening so you are never facing it alone.